If you've been watching our video, How Do Civil Lawsuits Work in Ontario?, then you might have heard of the term discovery plan. But what is a discovery plan and how does it work? You might remember in our other video that we mentioned a discovery plan is a way for lawyers to plan certain steps in a lawsuit. In this video, we'll go into a bit more detail about how discovery plans work. If you've seen our video, then you already know that people involved in civil lawsuits in Ontario must exchange evidence between each other and answer questions that are asked by each other's lawyers. All of that happens well in advance of a trial, and unlike what you may have seen in the movies or on TV, the process is designed to ensure that there are no surprises on the day of the trial. In Ontario, a discovery plan is basically a written agreement that is typically signed by the lawyers involved in a civil case, so that they can agree on things like deadlines to exchange evidence between each other, and what kind of evidence should be included in the lawsuit. You might remember that we told you about a legal term called the close of pleadings in our other video, which is a milestone in a civil lawsuit. One of the reasons that milestone is important is because the discovery plan must be signed and agreed upon 60 days after the close of pleadings. That deadline can be extended if the people involved in the lawsuit agree to it. Also, the discovery plan must be agreed upon before anyone in the lawsuit tries to obtain evidence from the other person, regardless of any of the deadlines we've mentioned. So, what kind of information is in the discovery plan? Well, the discovery plan usually outlines the date that the plaintiff and defendant must exchange their affidavit of documents. If you aren't sure who is the plaintiff and who is the defendant, or what an affidavit of documents is, then feel free to watch our other video, How Do Civil Lawsuits Work in Ontario? The discovery plan also identifies who may be required to answer questions under oath during the lawsuit, and what they can be asked about. The discovery plan can be a very detailed document, and it can even describe exactly how many hours a person must participate in being questioned before the lawyers must stop asking questions. However, to be clear, if the case goes to trial, then many of the same people may be called upon as witnesses to answer questions and testify at the trial. Some people might find it confusing why they may have to answer the same questions at different stages of a civil lawsuit. That's because the process of discovery happens out of court and without the participation of a judge. But a trial happens in a courtroom, with a trial judge who can decide the case. Oftentimes, the plaintiff, defendant, and their lawyers will decide to settle the case without a trial, because the process of discovery helped everyone involved in the lawsuit to understand the evidence and the testimony in advance of any trial. It often becomes clear who will most likely win the trial without the time and expense associated, without actually conducting the trial. Therefore, having a good discovery plan and following that plan closely can save many people a lot of trouble in many civil lawsuits. There can also be consequences for failing to agree upon a discovery plan. For example, you might remember that in our other video, we mentioned something called a motion, which is a way for lawyers to ask a judge to make decisions about procedural issues in a case. However, a judge can refuse to give the lawyers what they are asking for during some types of motions if the judge finds out that the lawyers failed to agree to a discovery plan. So, now you know the basics of how discovery plans work in Ontario. However, the discovery plan is just one small part of a civil lawsuit. And if you haven't already finished our video, How Do Civil Lawsuits Work in Ontario?, we encourage you to go back and check it out. Please note that this video is not intended as legal advice, and you should always speak to a lawyer if you have specific questions about your own unique situation.